Namaste, my name is Amish Tripathi and I'm the director of the Nehru Centre, London. Now, some may think of Nehru Centre as just this beautiful fine building, and it is a fine building, no doubt. We have a wonderful art gallery out here. We have an awesome auditorium on the first floor with a capacity of 100 to 120 people right here in the heart of central London in Mayfair. But the Nehru Centre is a lot more than this fine building. The Nehru Centre is also an online platform. We are available on Twitter, on Facebook, on Instagram and on YouTube. And so the Nehru Centre is actually wherever you want it to be. Of course, we'd love for you to come to the physical events that we organize out here when we do organize them. But do join all our online platforms as well. This is a hybrid world. We are going to have offline physical events and online events as well. So do join our online platforms and do keep giving us feedback of what you think of it. We'd love to host you out there. We'd love to hear what you think of our events, and do keep sending in your suggestions as well. We do keep imbibing and learning from the feedback that you give to us to give you programs that you guys might enjoy. Thank you so much for your kind attention. Namaste. Jai Hind.
This compassion which we inherit is also an inheritance of the past on who we are as Indians and who we are as a community, and how have we imbibed the values of who we are from the distant past, the not so distant past, and from the present itself. So these are all the constituent elements which go into defining our sense of compassion as a nation today. And I do believe that you take out compassion from judging, and you'll be left only with the husk, so to speak, of judging. The essence of judging is compassion, which is really the truth and the sense and the substance of who we are as a community of judges.
I couldn't agree more with you, sir. And before we carry on behalf of the host of the evening, Deputy High Commissioner Sujit Doshi, I'd like to also welcome Lord Ranger, Lord Gilmore. Thank you so much, sirs, for joining us. And I'm doing this on behalf of the host. Actually, sir, if I may move to the next question on this. There is a question that arises a few times, and it's more in the higher courts. That we think that the fact that the language used in our higher courts and the Supreme Court is still English, which vast majority of Indians are uncomfortable with, even those who know English. It may not be their first language. Many of the procedures would be a little foreign to them. So is there a case to be made that much of our higher education is still colonial and therefore a little difficult for the vast masses to access without the benefit of a good lawyer?
The primary audience of the judicial process is, of course, the litigant who is before you, because you are rendering justice to that litigant, and or both the litigants if they are private parties, or if there's one litigant who is a private party in the state. So you're trying to balance the needs of justice. So you speak to the parties before you in the primary sense, but your secondary audience, which is perhaps even more important, because that's when you speak to the entirety of the community, not just to the parties who are before you, particularly in the Supreme Court. When we lay down law, we are of course laying down law in the context of the dispute between private parties, but we are also speaking to the community of what we envision as a just society in our country. Now, with that sort of an object which we as judges seek to achieve, it's important that the language of our discourse must be understood by the people for whom that language is meant. And we should not be speaking an alien language. Now, Article 348 of our Constitution provides that the proceedings of the Supreme Court and of all the High Courts should be conducted in English. And let's also trace the reason why the constitutional framework. I mean, there were very distinguished drafters. Dr. B.R. Ambedkar led the drafting of the Constitution. And the reason for this provision was that India had adopted the common law as its legal system. And a number of legal principles were drawn from the courts in England at that time. But there was a more fundamental reason, which is that the Supreme Court and the High Courts are courts of record. The precedents of the Supreme Court can be cited across the country. The precedents of a High Court can be cited across the country. Various decisions of the High Court are in challenge before the Supreme Court. Now, in order to ensure the uniformity in the interpretation of the law and to represent a unified judicial system, English was adopted as a language of court proceedings by the Constitution for the Supreme Court and the High Court. Now, that's constitutional doctrine. The reality is a little different. And I can share with you, because I was a judge of the Bombay High Court for 13 years, and then I moved as Chief Justice of the Allahabad High Court, where I was Chief Justice for close to 3 years, actually 2 years and 7 or 8 months. And the reality is a little different. For instance, when I moved as Chief Justice of the Allahabad High Court, the proceedings would of course commence in English, And the lawyers are used to saying, "May please you, my lords," when they open their arguments. Now, this my lord has become more of a takiya kalam more than anything else. So when the lawyer forgets what to say next, they tend to say, "My lord," only to fill in the gap. Not because we are lords. I would be happy if people call us sir. But the point is, the moment you asked a question, the lawyers would address you in a language with which they are comfortable, which was Hindi. And I had no problem about the fact that the lawyers would speak to me in Hindi. I would begin with a caveat by saying, "Please forgive me for my response in Hindi, which is Bombaya Hindi Mishrit. My language may not be completely pure, but they took to you because they realized that you're making an effort to make yourself understood in a language which was close to everybody's heart. And of course, it's our national language, so I take great pride in the fact that I could address everyone in English in and outside the court. It's a language where I learned as a student of my graduate education. I have read extensively Hindi literature, and therefore I believe that it's important to make yourself understood in the language of the people. Now, the point which you make is really well taken, because it's important that the judgments of the Supreme Court and of the High Court, which are delivered in English, must be made known to citizens across the country and in a language which is known to them. And incidentally, the Honorable President of India raised this point at a lecture which the Honorable President delivered while addressing the Constitution Day celebrations in the Supreme Court. Why can we not therefore make these judgments of the Supreme Court particularly available to all Indian citizens? And technology provides us a solution. In the olden days, we had to sit down and get a translator, appoint a whole team of translators. Technology today does that, at the click of a button. So the E-Committee of the Supreme Court, I chair the E-Committee of the Supreme Court. We have a segment on the use of artificial intelligence. And one of the missions of the E-Committee, and guided by the Chief Justice of India, is that we must be able to translate our judgments into all Indian languages so that citizens can access them. The services which the E-Committee provides, including, we will speak about that a little later, all the services which we provide, including our manuals for how should you e-file documents. Now we are providing for e-filing of documents in court to facilitate and facilitate judicial proceedings and curb laws delays, or various other services. We send SMSs to litigants on when their case is now going to be listed. We send emails free of charge to litigants. In fact, the figures which I'll talk about if we have a little time. So all these services which we provide must be provided in a bilingual form, in English as well as in the local language which is available to the litigant. So we are increasingly using the languages which are in vogue across India for disseminating our services. So though at a certain doctrinal level, yes, the language is English, the actual reality is very different. So we are very, very relaxed in the use of any other language, particularly in the courts in which we preside. Even in the Supreme Court, I may not be able to speak Kannada if I get a Kannada litigant arguing before me. But certainly, if I have a litigant who is conversant with any of the languages which the judges on the bench use, we are happy to converse with them and make ourselves known in a language which they can understand. The Supreme Court makes it a little more difficult because it's a national court, and therefore, we have to have a unified language which we can use for the record.
Fair. In a country of our scale, with the number of languages that we have. So, at the line below the Supreme Court logo is Yato Dharma Sato Jaya, which is from Mahabharata, and where there is Dharma, there is victory. But often what ends up happening is one may not be able to benefit or get victory from it if many cases take too long. There has to be a victory of justice, but it has to happen smoothly and fast enough that there is a sense of justice coming in at the right time. This is an issue that, yes, the Supreme Court has reduced much of its cases, but Now the lower courts are still quite high. How does one address this?
Well, I might almost sound to be cliche when I say that, we all learned about this doctrine called justice delayed is justice denied. And then the flip side is, but justice hurried is justice buried. So, how do you find the balance between the two? Now, one of the major issues which is faced by the Indian judiciary is the pendency of cases. There are today 70,852 cases pending before the Supreme Court, out of which 52,000 are pending admission, that is the initial hearing. There are about 5.97 million cases pending before the High Courts and 42.1 million cases at the level of the district courts. So there's a huge backlog of cases which we can confront. What are the reasons for the delay? The delay is, of course, first numerous reasons, and I just only highlight a few of them. I might have missed some. Is the low judge to population ratio in our country, which is amongst the lowest in the developed nations. The lack of judicial infrastructure, sometimes frivolous litigation, multiplicity of cases arising before different fora on the same point. A case may involve a real estate dispute. The same litigant would try and use access to the consumer fora, to the National Company Law Tribunal under the Insolvency and Bankruptcy Code, so on and so forth. But there is another issue as well. As after 1990, as the economy has opened up and India has moved from a tightly regulated socialist economy into a market-driven economy, we've had a spate of regulatory statutes which have been enacted by Parliament in national interest, and you need those statutes, whether it be for the regulation of securities, or competition, or for the environment, or electricity, income tax, company law. So you have a tribunal governing every specialized act which the Parliament has enacted. Now, very often what has happened is that these tribunals have been set up without an effective legislative audit of the consequences of setting up the tribunal. And I think it's important that, at least from here on, the lawmakers and, of course, the government as the mover of the law must conduct a legislative audit of what is going to be the impact of the law. I'll just give you a very simple example. Section 138 of the Negotiable Instruments Act was enacted, as a result of which the dishonor of checks, which was earlier a civil dispute, because A lends 100,000 rupees to B and A gives a check which is dishonored, we can file a suit for recovery of 100,000 rupees with interest from A. Now, Section 138 converted it into a criminal wrong. So a person who is convicted can be sentenced to imprisonment, plus there can be an award of compensation, which is usually represented by the quantum of the check which was dishonored. Now, what has happened is that something which Parliament did to ensure that people pay their debts on time have resulted in literally lakhs and lakhs of cases coming to our magistrates' courts, and we don't have the number of magistrates to deal with these cases. So when new laws are enacted, which are undoubtedly necessary, there's no denying the fact that these laws are necessary. We have to also ensure that we strengthen the judicial infrastructure into ensuring that the backlog of cases is curbed. There has been a radical shift in thinking in the last few years. After independence, very little importance was placed on developing judicial infrastructure. Of course, there was a great deal of importance on developing heavy industry, on investment in education, in infrastructure, and so on and so forth. But on setting up hospitals and primary schools, important in itself. But people didn't realize, and I think the policymakers didn't realize the importance of the role of the courts in the overall economy. Unless you have a strong rule of law, you will not attract investment. And particularly now that there has been an emphasis on the ease of doing business, it's important that there is an adequate investment in terms of resources for our courts. Because when we have courts which are well resourced, when they're able to deal with problems on time, in turn you will be able to attract investors. Otherwise, there's always a great danger that people who are not able to resolve their disputes on time will take to extrajudicial methods to resolve their disputes, which is a very dangerous thing. And this is not only in the context of, say, commercial disputes. Take the case of matrimonial dispute. If a matrimonial dispute is not going to be resolved, say, until a decade is over, or more than a decade, and take the case of a young couple which has a problem at the age of, say, 25 or 27, and if you're not going to resolve their dispute until they turn 40, valuable years of life are lost, and that affects the social fabric as well. So a great deal of importance has to be given. I think a thought has to be given by the policy planners. Now, to the last part of my response to your question is, what can we as judges do about it? Because so much of it lies beyond our control, right? Because the courts have to be funded by the executive, and funding is with the government of the day. What can judges do? And this is something which is not known across India, particularly, not even known to lawyers. In fact, recently we had a very interesting interaction with the Parliamentary Standing Committee on the Department of Justice, and we interacted with members of Parliament across political lines, and we were delighted that they came to the Supreme Court. They spent a great deal of time understanding the work which we are doing in terms of technology in the Supreme Court. And I want to spend just a minute on that because I chair the E-Committee of the Supreme Court. And I have constantly been really emphasizing that technology can be leveraged to increase the efficiency and effectiveness of the courts. And we are in the E-Committee, we are focusing on using technology to transform judicial infrastructure. It's a very important link in making our judiciary modern. Just to give you a few examples. During the pandemic, the first example is video conferencing. When the lockdown started in March 2020, if we didn't have a robust technological infrastructure, our courts would have to shut down. And people wouldn't have been able to access courts, get bail, get their disputes resolved in courts, whether on the civil or the criminal side. Now, during the pandemics, the court shifted to hearing cases virtually. This allowed us to ensure that at least initially, matters involving personal liberty could be taken up by courts. And as of April 2022, the courts in India have heard nearly 19 million cases through video conferencing facilities. And across the world, this is unheralded. I don't think any other country in the world has been able to use technology to the extent that we have used. But this is all not necessarily reported because this may or may not be exactly newsworthy. Of course, for me, it is newsworthy.
19 million is newsworthy.
Yes.
Round of applause.
Now, we've been encouraging the use of e-filing for filing cases. So, just to give you an example, we deal with, say, about 65, 70 cases. There have been times when we have dealt with 100 plus cases on a Monday and Friday. And our support staff would be carrying these piles of cases on their shoulders. All that is gone as a result of the pandemic. My entire universe of cases is now contained in a digitized form, which I operate on my laptop. The notes I make on my laptop, all the judgments which we dictate are given to us in a digitized form on the laptop. We edit them on the laptop, and our orders are uploaded on the internet. We have the National Judicial Data Grid. Those of you who are interested may actually like to surf the internet and just do a Google search on National Judicial Data Grid or NJDG. Now we have 25 high courts. On the NJDG, we have 59.70 lakh cases which are pending in India. We have full details of those cases on the NJDG. There are 3.35 crore disposed of cases, details of all of which are available on the NJDG. As a result of which, we have details of 678 districts in India, 3,390 court complexes, 8,145 court establishments, and 21,061 courts. So the NJDG, for instance, contains comprehensive data, and it's really a mine of data for use on artificial intelligence, which is mapped on the NJDG. We have virtual courts, which have been set up during the pandemic. Now, one of the first uses of AI in the Indian judiciary was by setting up virtual courts. The Delhi High Court set up virtual courts, and close to 2 dozen judges in Delhi were doing the work of traffic challans, traffic ticket cases. As a result of the setting up of virtual courts, the entire process is mapped on the electronic platform, and the work is pretty much formulated, and the work is handled by maybe one or a couple of judges. So imagine in terms of the access to the citizen. Normally, a citizen who has to pay a fine can either pay the fine on the spot. If the policeman catches you, crossing the zebra line and says you have to pay 2,000 rupees, you can either pay the fine on the spot, or if you want to contest it, you have to go to court. If you have to go to court, you have to get a lawyer, spend a day. An auto rickshaw wala or a truck driver has to spend the day in court, go to the court, but the case is adjourned, go multiple times. Now with virtual courts, all that they have to do is that they get the summons on on a smartphone or any other phone that they have. You go to the State Bank of India, you pay the fine. That is logged onto the on the virtual register of the judge, and the case is knocked out of the system. So these are some of the instances where we have been able to leverage technology. But above all, on delays, and that's the human element, which I think is equally important, which is one of the reasons for Tariq Pe Tariq, as one of the Hindi films called it. Yes. And one of the reasons
you don't expect a Supreme Court justice to quote Sunny Deol.
One of the reasons for that is I think there has to be a change in the mindset on the part of lawyers as well. So often, in the Supreme Court, even in the Supreme Court, a lot of these judges find that it's far easier to decide a case than it is sometimes to get a lawyer to argue a case. So I do believe that there has to be a change in mindsets so that lawyers are ready to get on with their cases, argue cases, not constantly be haranguing the judge when the judge wants to go ahead with the business of the court. And this I speak of the Supreme Court, where we have a degree of authority, because we are the final court. You can imagine what is the plight of a civil judge junior division sitting in a remote part of the country, in a small taluka establishment. That judge can be, very often our judges are threatened. They might be told, well, if you act smart, we'll have you transferred from here. There are local pressure groups, and you're dealing with judges in their 20s and their 30s who are, in that sense, who are trying to do justice. And there is so much that the judge can do, and there's so much that the bar should do as well, which I think it's important, therefore, that we change mindsets of lawyers as well and make them appreciate that merely because you have a client who may be on the losing side, you ought not to be doing every trick in the rule book to ensure that the case does not get heard. Very often you find that that lawyers are very eager to argue an application for bail, but when it actually comes to arguing a case finally in an appeal against a conviction, judges in the High Court also say it's very, very difficult to persuade lawyers to argue the criminal appeal. That's not the only reason why criminal appeals are pending. Don't mistake me. Criminal appeals are also pending because of the lack of adequate number of judges. So very often then the judges are told by the lawyers, well, I've been only briefed to argue the application for bail. If you're not granting me bail pending the disposal of the appeal, I'm not going to argue the appeal today. So these mindsets have to change. And I don't know what we can do to ensure perhaps better legal education, changing the atmospherics in the courts. So the burden of this is not just on the judges, but on wider society, on the policy planners. So action has to be taken at multiple levels.
Well, that's that I would certainly agree with. A lot of action has to be taken, but I think one of the things that people will acknowledge, and perhaps we should, with the positives that I didn't know about the way traffic times are now handled. This is a huge innovation. We should celebrate the positives as well to get a sense of momentum. I would like to, of course, have the audience also have the opportunity to ask questions. I don't want to monopolize your time all the time. But if I may ask one, I'll come back to that. But the Deputy High Commissioner had a question which we'll have a mic come up to him.
I think it's been answered. So,
Okay, then I should to one more question of mine. Do you think this may be slightly technical, but much of the audience are lawyers, so they may understand it. Do you think that there is a problem that in the Supreme Court being a court of appeals and a constitutional court at the same time in India? So therefore, lawyers who should be stepping back and mulling deeper constitutional questions, judges, are also forced to clock their bandwidth up listening to appeals. So they are kind of two competing functions. And is it better to have, especially in such a large country, is it better to have that in two different courts? What is your thoughts on that?
There is, of course, we have models across the world where the Supreme Court is clearly demarcated as a constitutional court. I think the classical illustration is the US Supreme Court, which is a constitutional court, which of course hears cases bearing upon the constitutional issues under the US Constitution and state disputes which also implicate federal constitutional issues. Now, when the Indian Constitution was drafted, a different model was adopted. The Supreme Court is not just a constitutional court, the final arbiter of disputes in constitutional cases, but it is also a final appellate court. And the reason is that unlike the United States, where you have a dual judiciary, the state judiciary and the federal judiciary, in India, though of course we have what is called the state judiciary, we have the district courts, and then we have the high courts. But you have a unified judiciary in India. That is, you have the district courts in a state, the high courts, and then you have a Supreme Court. And there's a unified judiciary in that sense in India. Now, what the Constitution did was it gave the Supreme Court final appellate powers, and it gave the Supreme Court constitutional powers as well, Article 32, to deal with disputes involving a violation of fundamental rights. The High Courts have constitutional powers, Article 226, where they can deal with a violation of fundamental rights or any other legal right. But they're also courts of appeal. So an appeal, say, from an order of the district court lies to the High Court, the first appeal. And then there's a specially petition to the Supreme Court. An appeal against an order of a civil judge. The first appeal will go to the High Court, the second appeal to the High Court, and then the first appeal to the District Court, the second appeal to the High Court, and then the final Article 136 to the Supreme Court. Now, the Constitution says, and I don't want to get into the technicalities, the Constitution says that the Supreme Court can hear a petition where on an issue of substantial public interest arising from an order or judgment of any court or tribunal in India. Why did the Constitution do that? Again, very visionary drafters of the Constitution. The reason the Constitution did that was that they wanted that the Supreme Court should be this national unifying force for law and justice in the country. And that is a very significant aspiration which the drafters, led by Dr. Ambedkar, very distinguished members of the Constituent Assembly, came to adopt for India. They were conscious of the fact that this is essentially a very poor society, a society which is ridden by discrimination, caste, patriarchy, and they wanted this national court to be a sort of an umbrella unifying force for the whole of the country. We have to put ourselves back into what India was when the Constitution was framed. A nation which had suffered partition, a nation which had suffered the horrors of partition. So there was this aspiration that this would be a unifying institution, a national institution for the whole of the country. And now I'll tell you how it has panned out. It's very difficult sometimes to distinguish between something that is purely constitutional and something which is purely appellate. I'll give you a very simple example. Just a month ago, before we closed for the vacation, we had to decide an issue involving the goods and services tax. And the issue is whether goods and services tax can be levied on the ocean freight element in the case of a CIF contract, where the foreign exporter engages a foreign shipping line for the transportation of goods to India. Now, can GST be levied on the service element, namely the service which is rendered of shipping the goods to India? That was the point of tax law. But in the context of that, we had to also interpret the provisions of the GST law which has been engrafted by the constitutional amendment in India. So this was one example where it was not just the appellate issue that we had to consider, but the constitutional issue. Apart from this judgment in Mohit Minerals, for instance, something as simple, I'll give you a very mundane, a seemingly mundane example. The union government came out with a policy that there shall be no transfers from one commissionerate to the other in the central excise department of the country. Now, this was challenged before the Supreme Court. Now, we had to deal with the issue because a lot of people challenged this on the ground that this works against the interests of women who will be denied a spousal transfer because it is a transfer from one commissionerate of the country to another. A very simple issue of service law also involved constitutional issues. Is there a constitutional issue why two spouses who are both employees of the central government in the commission of in the central excise department must have, as a matter of fundamental rights, the ability to live together so as to promote their family life, to be of assistance to their children, to be associated with each other during the course of their service careers? Or another very interesting example recently before us, we dealt with the issue of disability, where the issue before the Supreme Court was, can a person who suffers from a writer's cramp and is appearing for the civil services exam, is he or she entitled to the facility of a scribe as a matter of right under the Rights of Persons with Disabilities Act, which Parliament has adopted? And we said they're entitled to it as a matter of right. Recently, we had a case where a constable in a paramilitary force was dismissed from service on the ground of misconduct. But the rub was that the constable was suffering from a mental health issue. So we said, well, you could not have dismissed the member of the paramilitary force from service merely because they were suffering from a mental health issue. The principle of reasonable accommodation, which our law embodies, requires you must accommodate them somewhere else where they may not have access. They will not have access to firearms, so you can do a non-sensitive job. Now, the reason why I mentioned these three examples is look at the width of the power which has been given to the Supreme Court. And this width of power has been given to the Supreme Court so that different high courts don't take conflicting views on legal rights while deciding cases. Article 142 of the Constitution, which is perhaps unique to our Supreme Court, Article 142 entrusts the Supreme Court with the power to do complete justice. So that even if you have to decide a case where the law is silent, for instance, the Supreme Court has been given that power, not any high court. And the framers probably understood that there may be some issues of the rights of citizens, where ultimately you must entrust this power to the Supreme Court to do complete justice by issuing directions which will subserve the facts of that case without creating a precedent for the future in the high courts. So in that sense, while there is a great deal of merit doctrinally in the argument which was made that should you not have a Supreme Court which will exercise only constitutional powers, I'd say doctrinally, that's not the vision of our Constitution. The Constitution has envisioned this as a much broader institution in the context of poverty, in the context of discrimination, and as a national unifying force to produce one cohesive nation and to use the law to provide for legal principles which will knit together this nation of different cultures, different languages, different aspirations into one national society.
If anyone has any question, please raise your hand. But I'll just come because this is, if you could allow me, just one question that builds on this. Because actually it's a very complicated. Sorry, I'm the guy on the stage. So I'm going to use that right. But because one thing which flows very naturally from, because the complexities of the issues and India is a complex country. All our governments face such complexities. is there a value in exploring something like an Indian judiciary service so that many of these issues can, if there's a service which goes through, the lower courts, high courts, a certain part can be, let's say, one certain part can go through the service. Is there a value in exploring something like that so that many of these issues then become a part of the discussions, training within the service, and therefore cascades down across? What do you think of that, sir?
Let me give you first the model which the Constitution has adopted. The Constitution has adopted a model where the district judiciaries in India are under the administrative control of the high courts. Now, therefore, appointments to the district judiciary are made within each state. And typically, the examinations which are held for recruitment of judges to the district judiciary are held in the state. There's no national examination. Appointments to the High Court are made not within the state, but they are made, of course, by the President of India. And there's a detailed procedure and the memorandum of procedure which has been adopted for making appointments to High Court judges. Now, in the district judiciary, judges are appointed from two sources. Judges can be appointed at the lowest level, which is the level of the civil judge junior division or the magisterial level. Judges are also appointed laterally at a more senior level as district judges after putting a stipulated number of years of service. To the high courts, the Constitution has adopted a dual framework, namely that lawyers can be appointed as judges of the High Court after putting in a stipulated number of years of practice, or lawyers can, or the district judges can be promoted to the High Court, provided they have a certain degree of seniority or stipulated number of years as district judges. And of course, to the Supreme Court, you can have appointments which are made from three sources from the High Courts. Therefore, district judges who have come to the High Courts can become judges of the Supreme Court. Lawyers who have been appointed to the High Court can become judges of the Supreme Court. For the Supreme Court, there is a third source, which is the source of an eminent jurist. There's been no appointment over the last 70 plus years of an eminent jurist, but that's a provision which is made in the Constitution. Now, the proposal which was initiated initially in 1958 by the Law Commission and which was being also discussed in 1992 in the All India Judges Association case by the Supreme Court, but it was ultimately left by the Supreme Court to the Union of India to take an initiative in this issue. 2017, the Supreme Court again took notice of it of its own accord. The proposal was really that you can have an All India Judicial Service so that you can have appointments to the district judiciary, which is really in that sense monitored or supervised by a national umbrella authority. And one of the considerations, I really don't want to go into the merits of the proposal because it's still pending consideration before the government and the Supreme Court, and therefore I'll not hazard an opinion, but I'll just broadly indicate what the contours of the proposal or the contours of the issues which arise are, which is that very often there is a delay in the process of appointment of district judges. The Supreme Court is monitoring that process in a case which is very famously known as the Malik Mazhar Sultan case. So, because the High Courts make those appointments, the High Courts make those appointments in consultation with the public service commissions in the High Courts, and the governor of the state makes the appointment once the High Court has gone through the whole process. Would that all be obviated if you had really one examination for appointment to the district judiciary? That's one of the issues. But on the other hand, in a country like India, which is a federal country, that also implicates, the status of our states in the federation, because the constitution, as it has been adopted, the states today have a very vital role in the appointment of district judges. So the issue of federalism has also to be taken into account, by which I'm sure would be a matter of discussion and debate as between the union government and the states, each of whom are vital stakeholders. And obviously the judiciary, which is a vital stakeholder, because different high courts may have different perceptions on the problem. But insofar as having a unified judicial service for appointment of all judges in the system. That all judges in the High Court also should come from the judicial service, or all judges of the Supreme Court should also be promoted from the judicial service. The model which the Constitution has adopted is not that. And interestingly, one last point I'd like to make is that, since judges are drawn from these two different sources, from the High Courts, we have judges who come from the district judiciary, and we have judges who come from the bar. Now, the great value of that model which we have adopted must also be understood, which is that typically judges who come from the district judiciary, and I've had the benefit of sitting with judges who come from the district judiciary, and as a member of the bar, I practiced at the bar, and I then became a judge, and I sat with a lot of district judges who came to the High Court. The district judges bring a sense of continuity, of experience, because they are well versed in criminal law, in civil law, in the trial of cases. So when they come to the High Court, they bring a very different perspective into the High Courts. The bar judges who have been lawyers, they bring a perspective of freshness, because they've argued cases, they know the problems of litigants. Likewise, in the Supreme Court, for instance, when I sit with a colleague who has come from the district judiciary to the High Court and to the Supreme Court, their perspective on the problems of law and life are very different. So if I sit, for instance, with a colleague who has come directly from the bar to the Supreme Court, their perspective is very different. So it brings a very enriching experience to us, not just when we decide cases, but when we sit together. We sit in the lounge in the morning, we discuss the problems of the court in the morning over a cup of tea. They have a very different perspective. For instance, some of the very distinguished judges in the recent past, Justice Lalit, for instance, who is the senior most judge of the Supreme Court, or Justice Nageshwar Rao, who has just retired, or Justice Indu Malhotra, who has just retired, or Justice Rohit Nariman, who has just retired. These were lawyers who were typically appointed to the Supreme Court in their late 50s. Now, because of the fact that they were very closely connected to the bar until recently, they were in close contact with the pattern of litigation in the Supreme Court and across the country, because they traveled across the country when they argued as counsel. So when they came to the Supreme Court, they brought a freshness of adjudication. I was appointed as a judge of the High Court in 2000, so I've not been a lawyer now for almost 22 years. So this is like a melting pot of experiences. Of people who come from the bar, people who come from the district judiciary, judges of the Supreme Court who come from the High Court. So we bring our own set of experiences on adjudication. And I think there's a great value in what the Constitution has adopted in our present system. And I actually see it unfold from day to day when I sit with colleagues, both on and off the bench, and we share a lot. Our peer learning is not in terms of just the cases which we decide or the judgments which we read of each other before we deliver them in court. But our peer learning is also in terms of the experience which we share in formal and informal settings. We take very important decisions as members of the collegium in the appointment of judges. So as members of the collegium, when we sit together and we discuss, and some of our discussions are very animated, we also learn from each other, we share from each other. And the diversity of our experiences is, in that sense, it symbolizes the diversity of India itself. And it signifies how, despite being such a diverse country, we all come together in the formulation of this one identity as a nation, bringing to the table our own experiences and enriching each other in terms not only of where we come from, the region we come from, the language we come from, the language which we speak, or our cultures, but also where we have come from before we became judges, our genders. So I think all in all, this really is a process which promotes a great deal of enrichment in our dialogue.
Fascinating insight of this. I think we have space for 2 questions. So if a mic could be given to Deputy High Commissioner, please.
So I'm taking this liberty to pose this question for your consideration. You had alluded to it in your first address a couple of days back. Now, you just mentioned about peer learning and how judges learn from when they interact with one another, they learn from one another. But on that occasion, you had also said that there is a need for more capacity building maybe judges in Delhi or in state capitals have much more access to resources, international resources, in terms of capacity building. Do you also see some scope in terms of capacity building for other people in the judicial system, in terms of their international exposure or in terms of their learning internationally? Is there any scope for that?
Actually, the exposure, say, in different parts of the country may vary depending upon the kind of litigation which comes to that court. For instance, say in the Bombay High Court, you have the admiralty jurisdiction. So if there's a dispute over a shipping dispute, you invoke the admiralty jurisdiction of the Bombay High Court. You have to arrest a ship. So that's the exercise of the admiralty jurisdiction. Now, a court in the hinterland would not have much experience with, say, dealing with the admiralty jurisdiction. There may be courts which are very highly commercial courts. There are some courts which have original jurisdiction. So you can file a suit in the Bombay High Court, Bombay, Calcutta, say Madras, Delhi. You can file a suit directly in the High Court on a commercial dispute of a certain minimum value. Courts which do not have original jurisdiction, those High Court judges will not know what is the trial which is conducted for the first time in the High Court. The district judges who have come to the High Court would, of course, have conducted trials as civil judges. So there is a diversity of jurisdiction depending upon the nature of urbanization in the state. Highly urbanized states would have a different pattern of dispute. Highly commercial states or industrialized states would have a different pattern of disputes. A rural state where the predominant source of income or livelihood is agriculture would have a slightly different pattern of disputes relating arising out of land. Now that's obviously going to change as the progress of the fruits of development reach across the country as they are. Now capacity building for judges therefore is important. And I think technology is a great leveler because technology allows us to tap knowledge and resources across India, irrespective of where you're situated. But one thing which we need to also look at is beyond the judiciary. We have judicial academies. We have the National Judicial Academy, which is at Bhopal, which looks after the training of all judges, particularly High Court judges as well as district court judges across India. And then you have the State Judicial Academy, which look after the training of judges within the state. So there is in-career training for judges right from the inception. And Supreme Court judges also go to the National Judicial Academy. We also visit the State Judicial Academies. But I think we also need to look beyond and think out of the box. And recently, actually, looking at what is happening across India, particularly in the civil services, I've been deeply impressed with the model which the civil services have adopted since independence, of allowing for career development programs for our civil service officers. In fact, during my trip to London, I've been meeting at Oxford also. I've been meeting our civil service officers who have come on for doing postgraduate education across the UK or in different parts of the world. Now, what that really means is that they have the ability to imbibe a world view. It's not just in terms that you might be doing an MA in development economics, you might be doing an MBA. I graduated from St. Stephen's College in 1979, and so many of my batchmates joined the civil services, and many of them went on to do doctoral degrees, whether it was in finance, or it was in management, or it was in development or governance. Now, talking particularly to civil service officers, I chair many selection committees for appointing to tribunals in India. And I happen to converse with very distinguished secretaries to the government of India. And one thing which really stands out is that this facility which is provided to civil service officers to move beyond the frontiers of India and spend a year or 2 years outside India enables them to have a world view. Now, judges tend to be very insular, and we have to be a little isolated in order to preserve our independence. Now that is good, but that's bad for the system as well, because you must expose judges to the emerging new trends which are taking place across the world. Many of the laws which I have to deal with as a judge, I didn't learn in law college. I didn't practice those laws when I was a lawyer, because those laws were not in existence. We are learning now to deal with them for the first time. Take the case of the Insolvency and Bankruptcy Code, which came for the first time in 2016, by which point of time I was already a judge of the Supreme Court. So, a lot of our learning, therefore, takes place on the job. But it's equally important for us to, say, train our young judges in the high courts who would be eventually coming to the Supreme Court. Well, why was the Insolvency and Bankruptcy Code adopted by Parliament? What are the models of financial regulation which are pursued across the world? Because the world now is becoming one globally connected community, and India is part of it. We are not only attracting foreign investment, but we are sending investment across overseas. So a lot of those disputes come to our courts, whether it's in terms of intellectual property disputes, or whether it is in the context of complicated disputes on electricity, or the regulation of the securities market. So the modern disputes which are coming before us, even in the Supreme Court, are extremely complex disputes involving economic regulation. If our judges have to be truly equipped to understand why those disputes are coming before us, and of the position of our nation in the community across the world, it's important that we equip our judges. And though by sending a judge across, say, from India to the UK or the US, or Australia, or wherever, you might be taking that judge off duty for that 1 year. And therefore, so many cases which the judge would have decided would not be decided. But there's a wider interest to be served in terms of the national interest by making our judges have the necessary intellectual equipment for capacity building. And I think the benefit of that would accrue to the nation as a whole. So we must look beyond our national frontiers, or even within national frontiers, to allow our judges to pursue research, to allow our judges to pursue graduate and postgraduate degrees in various disciplines. And honestly, the benefit is not just in terms of the law which they would learn, but in terms of peer-to-peer learning, talking with the best minds internationally, talking among the best minds even amongst your students from India who come to these countries, and invite from them.
Especially since we follow a one-law system and judges can act through decisions. Very valid concept. Lord Dhananjaya, you have questions.
Thank you very much for enlightening us. We are very heartened to hear this your explanation of the Indian system. My question is, do Indian Constitution consider justice as a basic human right? If it does, do we provide legal aid?
I think the Constitution, in a whole range of provisions, does consider access to justice as a fundamental human right, because access to justice is very closely related to every one of the guaranteed rights in the Constitution, whether it be the right to life, the right to live with dignity, the right to equality, the right against exploitation, the right to be protected against discrimination. So I think justice is as fundamental as it can be. And in fact, the preamble of the Constitution, which is in that sense the charter, the basic set of values which define us as a nation, speaks of justice, social, economic, and political. So the Constitution in that sense speaks of justice in all its dimensions, not just social, but economic as well as political. Legal aid has been itself recognized in the constitutional principles of in the directive principles. But apart from that, now legal aid, we have a strong legal aid movement in India. You have the National Legal Services Authority, which is chaired by a judge of the Supreme Court, and you have the State Legal Services Authorities, which are chaired by the senior-most judges of the High Court. And we have a very strong legal aid movement in India. Having said that, there are deficiencies in the legal aid movement in India. because we must ensure that legal aid counsel are quality counsel. There is otherwise a tendency to sort of regard legal aid as not the best aid that is made available in terms of access to justice to the poor and the less resource. So the real challenge before us today is to ensure that legal aid is uplifted into quality legal aid. Otherwise, the legal aid is meant for the poorest of the poor, those who cannot afford counsel. And unless we do that, legal aid will degenerate into inadequate legal aid. There ought to be, I think, some mandate on lawyers doing a certain number of fee cases every year as a condition for continued licensing for designation as senior counsel. When you're selecting judges from the bar, there must be a mandate that you must have at least done a certain percentage of your work as legal aid. That's the way you will really be able to ensure that true legal aid flows down to the poorest of the poor in India.
Very good. Very good.
So if I may ask an online question, I hope you are those who interact. Vasundhara Saxena, she's asking, respected sir, is there a future for international investment arbitration in India? Singapore has emerged as a massive arbitration center in Asia and indeed across the world. So is there an opportunity for India to emerge like this?
Vasundhara, a very valid question. And I think the groundwork for India to emerge as an investment-friendly arbitration hub has been laid down by the recent decisions of the Supreme Court under the Arbitration and Conciliation Act of 1996, which is to say that the judiciary promotes arbitration, it respects arbitration, and it encourages and facilitates arbitration. As an adjunct to that the interference with arbitral awards and the arbitral process must be brought down to the minimum which the law contemplates. And therefore, the court must defer to party autonomy and to the autonomy which the law recognizes as inhering in parties to disputes. We have now arbitration hubs which are coming across India. You have arbitration hubs in Delhi, in Bangalore, in Mumbai, in Hyderabad now, which is being set up under the guidance of the Chief Justice of India in Chennai. And I think there's a huge amount of scope for the disposal of arbitration services in India, and for India to emerge as an investment-friendly arbitration center. I think there is a huge scope for that, and we need to seize upon the opportunity and to ensure that is done. There's an allied area, which is the ISDS mechanism, which is the investor-state dispute settlement mechanism, which a lot of developing countries have reservations about, because there was a perception that the bilateral investment treaties, which were negotiated in the 1950s and thereafter, were particularly skewed in favor of the developed countries, and they didn't take into account the concerns of the global south, particularly in matters of regulation by the state in public interest. So, for instance, suppose the state were to ban cigarette smoking or to place restrictions on cigarette smoking as an element of public health. Can a private invested arbitral institution decide upon the validity of the policy? Or if the state were to impose a tax, can the validity of that tax be adjudicated upon by an ISDS mechanism constituted under a bilateral investment treaty? India has therefore proceeded to terminate a lot of the BITs and has come out with a model BIT. Now, a lot of countries, particularly the developing nations, did have reservations. Environmental regulation. If a country adopts a certain policy in the interest of protecting its environment, can an international arbitration tribunal say that, well, your decision was wrong, when the government says, well, we've done it to protect our own public welfare and our public interests? Can that be scrutinized by an international tribunal? So that's a separate issue. But I do believe, in answer to your first question, that we can certainly take steps, and those steps are being pursued. But to do that, we must also produce a band of highly efficient arbitrators and arbitration council, which we already have in the making. And I see a very bright future for India as an arbitration hub, particularly in international investment disputes.
Wonderful. We have actually taken up a lot of time already, so I know this was truly a masterclass from one who has amazing clarity of thought on matters judicial. You've attracted a large audience despite the massive train strike today. You've seen the hands going up, but if you have 5-10 minutes,
Yes,
perhaps we will go to interact with you one-on-one offline.
Absolutely. If you're
Yeah.
left with some question, we can still do it.
Perhaps we can have one more. Okay.
And I'll be brief. I'll be brief now in my answers, so
Yes.
that I'll answer like a lawyer, not like a judge.
My only request though is do not ask on questions on any live cases. It would be inappropriate for the Honorable Justice to answer on that. We'll just have 2 questions and then he does have another engagement. You, sir.
Hi, sir. I'm Akshu Jain. Good evening, sir. I'm Akshu Jain. I'm a practicing lawyer at Delhi High Court. So my question is, do you think that having specialized benches in High Court can solve the problem of pendency of cases? Just like our High Court has IP division specialized. So with regard to that, we should also have criminal division specialized and some other courts which are particularly dealing in commercial matters.
You've made a very valid point, because the need of the hour today is specialization. So without having judges who are rigidly confined to a jurisdiction, you must have specialized jurisdictions and specialized judges. But I must tell you that does exist. Every Chief Justice who prepares a roster for who will decide cases always has this in mind. Who are your specialized tax judges? Who are your specialized judges in intellectual property? You from the Delhi High Court, practice in the Delhi High Court, and I'm sure that there are judges who are specialized in IP law. There are judges who are specialized in taxation. There are judges who are very highly specialized in commercial law. So these broad specializations are always borne in mind by the Chief Justices in preparing the roster, and must be borne in mind actually. Likewise, you have judges who are highly specialized in criminal law. So instead of judges reinventing the wheel and learning everything from scratch, if you have judges who have already done that particular type of work, it's good to have them decide that. I mean, the surgeons do that, isn't it? And you would want to go to a surgeon who specializes in that particular branch of surgery. So likewise, that applies across adjudication as well, where specialization ensures domain knowledge being applied to the area, and it also ensures that you have expeditious decision making. So specialization promotes expedition, but it also ensures that you have specialized decision making by a person who has domain knowledge on the subject.
You, sir. Yes.
Myself, Vishnu Bihari Tiwari from Allahabad High Court, India. Before elevating the Supreme Court of India, Dr. Justice had been our Chief Justice of the Allahabad High Court, which is the biggest High Court in Asia. I had an opportunity to read and appear judgments of Dr. Chandrachud, which are very conclusive and short. In very short of period, Dr. Chandrachud is going to be Chief Justice of India.
Sir, if I may request, if you could just ask a question, sir.
So my request is that as Dr. Chandrachud's judgments are very short and conclusive, we save the paper and time. So my request is the same Chief Justice, the other judges may also, which may conclusive and which may save time and paper, very short judgment as Dr. Chandrachud is giving.
I'll just answer it to it. Thank you for the compliment. I mean, who doesn't like a compliment? But I'm not sure that it's entirely correct, because I have written some long judgments as well, which I wish could be a little shorter. But my point really is this. The point which I want to make is this: that the reason why judges do write sometimes judgments which are longer than they should be is because we follow the common law tradition of precedent, which is that our judgments also serve as precedents for the future. Second reason each of our judgments, not the Supreme Court judgments, but the High Court judgments, are capable of being tested in appeal. So the appellate court has to know your reasons. So therefore, we follow the common law tradition of giving reasons for our judgments. And reasons therefore necessarily mean that you have to elaborate. Having said that, I'll just briefly say this, that it's also equally important that we don't fall victims of the cut, copy and paste culture of the age of electronic technology. And it's not necessary for judges to cite 50 cases. You can cite the principle in those 50 cases and footnote them at the bottom, which makes your judgment down to one particular paragraph, which summarizes the entire body of case law on that particular proposition. Sometimes I think judges write long judgments for the simple reason that they don't have time to write short judgments. But I entirely agree with you on the need for short judgments. Yes, of course.
I guess the last question, you ma'am. If you can just. Yes, sir.
What is the role of the Supreme Court on public interest litigation? The Supreme Court has passed landmark judgments on public interest litigation, particularly on environment.
See, PIL or public interest litigation is a truly Indian creation, if I can say that. Of course, there are precedents in the past where a letter written by a prisoner was treated as a petition. Indian was Wainwright in the United States. But as we see it, public interest litigation is truly an Indian innovation. So when I'm asked as to whether the Indian judiciary has very strong colonial traditions, I always say that, well, look at some of our own homegrown innovations, which are fully Indian. And therefore, PIL has a very valuable role, particularly in the realization of the rights of those who cannot otherwise access justice. So the fundamental principle of a PIL is that the person who moves the court has no personal interest in the case, apart from being a citizen. Now, unfortunately, all good things sometimes can be exploited and be misused. And part of our experience has been that public interest litigation, so Soli Sorabji had really coined that word, the distinguished former Attorney General for India. And he said that public interest litigation has tended to become publicity interest litigation. And there are other shades which I don't think I should be referring to as the sitting judge of the Supreme Court. But unfortunately, sometimes public interest litigation is also misused on certain occasions to stall development projects, to interfere with the award of contracts to rival business interests. I'm not saying that all public interest litigation is like that, so please don't misunderstand me, because I know of a whole lot of public interest litigation, some of which I'm dealing with even now, which have served valuable purposes under the Constitution. And sometimes the public interest litigation is not a battle between citizens and the government. Citizens come to court to point out the way in which the law can be enforced better. And it's a sort of it's a consolidated bipartisan coalition between citizens, the regulatory bodies, and the court to ensure that justice is truly done to our citizens. But we, at the same time, I think it is important for all judges across the system to be able to distinguish the grain from the chaff, to use PIL as a genuine methodology for advancing the cause of justice, and not allow public interest litigation to degenerate into a misuse of the judicial process, which then would ensure that the whole process comes into grave disquiet and disrepair, and then a great amount of damage would be done.
And this will be the last question. Go ahead.
Hi, Shri Rani, founder of Afro-Ghana. We find a number of cases where there's been malicious, vexatious litigation, strategic litigation, there's public participation, and a lot of that lead to delay in justice, but obviously people being dragged through the courts and having been abused by the litigation process. Do you think that the current system is in any way penalizing that? And you also spoke about rogue behavior by advocates. Do you think more needs to be done to curtail that kind of behavior?
On the first part of your question, I think I answered a bit of it when I was dealing with the previous question. But, a lot of us do have this spectacle of frivolous litigation. And I think that is one of the causes for the delay in the judicial system. We have to find out ways of curbing frivolous litigation. We are pretty lax or pretty flexible or liberal, I shouldn't say flexible, but liberal on the award of costs. Now, we need to rethink that because all judicial time involves the expenditure of public money. Every minute that I spend in the court as a judge implicates the public revenues. And not just public revenues. Every minute of time that you spend on case A means that you are spending that 1 minute less on case B, which could have been heard. So many cases which cannot be heard are perhaps not heard because something which consumed your time should not have consumed your time. So we need to find ways to disincentivize litigation which is not bona fide. And unless we do so, there's a great danger that the judicial process can be completely hijacked by litigation strategies which detract from the time that judges should spend on genuine causes of our citizens or entities which come to the court. And insofar as the second part of your question, namely the rude behavior, well, judges have, the authority under the law to deal with rude behavior.
Rogue behavior.
Sorry?
Rogue behavior, when advocates will continually delay in order to...
Right, rogue behavior. Right. Obviously, judges do have the power to deal with it, but you must also, you must really understand the real politics of all of this. The higher you go, the greater the degree of authority which judges wield. But even at the highest levels, you expect a degree of self-regulation by professionals who appear before you, because as judges, you do not want to give the appearance of being a headmaster in a court. You are a facilitator of justice. And therefore, there is, while the judges have very wide powers, particularly the higher levels in the high courts and in the Supreme Court, I think the responsibility of correct behavior must also be assumed by every stakeholder in the system, whether a party in person or a member of the bar, because ultimately, the nature of the behavior becomes a new norm in the system. It shouldn't be that a certain pattern of behavior becomes a new norm or the new normal in the system. And why should we only depend upon our judges to control rogue behavior? That must also be controlled by the professional bodies of lawyers and by good lawyers setting an example to others by the manner in which they conduct cases. A lot of peer learning takes place in the court. So when lawyers who others look up to argue their cases, they learn on what is etiquette in court, what is the manner in which a case should be conducted, when you should not press a point which would be dishonest to press in the court, that you ought not to press a point on which you do believe that there is no substance at all. Therefore, as we say that a lawyer above all is an officer of the court, now increasingly that may be becoming a sort of just an aspiration to say that the lawyer is an officer of the court. But that contains a very important element of truth, that the cause which the lawyer represents is not just the cause of the client, but the cause of justice. And sometimes the lawyer must really understand that by virtue of their training, by virtue of their knowledge, they represent a much wider cause than just the immediate cause of the case before them. And this applies to government lawyers as well. Because when you appear for the government, you're not just defending the interests of the government, but you are there to secure justice for the citizens. So it works both ways, I think.
Amirji, can I ask?
Sorry,
Very simple question, sir. My question is. Sorry. Thank you. Hi, sir. I'm Anuradha. And my question is that do celebrity lawyers make an impact in the court?
This is Prasad.
Now, I wanted to ask, can I ask you a question? You know, this whole notion of a celebrity lawyer is, I think, a matter of public perception. I don't think judges, a good judge, I didn't think a good judge wouldn't really think of a lawyer as a celebrity lawyer. Speaking for myself, when a very young lawyer, very young junior struggling lawyer who is probably in their first few months of the profession comes into my court, I believe that the burden on me as a judge is infinitely higher to convey a sense of ease in the mind of that lawyer, to guide them. Sometimes, you know, the reason why they're not prepared may be because they're not as experienced. Or, you know, we come from a country where there's a diversity of legal education. Many young lawyers who appear before us may have not gone to the national law schools. Many of them may have learned their law or done their education in language mediums and not necessarily in English. So many of them may not be as well versed in putting a point across in English. So the authority which a judge yields is not an authority which is designed to produce impatience in the court. And speaking for myself, it's important. I always feel that even if it means spending a little more time, you must put a lawyer who's young, who is not as experienced, at ease. You must enable that lawyer to draw out the best in the case. Sometimes we also guide the lawyer to tell, what about this point in the case that perhaps the young lawyer may not have seen in the case. So there's a big burden which is cast on a judge, an obligation which is cast on a judge to ensure that the background of a lawyer, whether in terms of knowledge of the language or knowledge of the law or just experience in the bar, should not be a factor which should deflect the cause of justice. So the celebrity lawyers, yes, those who appear on television may appear to be celebrity lawyers, but I don't think that really is a factor which at least ought to determine the outcome of cases.
Thank you so much, sir. I'm afraid we have to call the event to a close now. But on behalf of the host of the evening, Mr. Jitpurji, the Deputy High Commissioner, I want to thank all of you for coming over to this event. Wonderful to listen to you, Dhananjaya, what a judge should be. Clarity of thought, depth of knowledge, compassion, desire to learn from other cultures, and yet a deep love and understanding for your land and culture. Thank you so much for coming to the Nehru Center. Thank you so much, sir.